Lesson: Tender of Performance. Tender of performance is a fundamental concept in contract law that reflects a party's readiness and ability to fulfill their contractual obligations. It involves a clear, unconditional offer to perform the agreed terms under the contract. Understanding this concept is crucial for professionals who aim to excel as certified contract law specialists, as it ensures both compliance with legal standards and the effective management of contractual relationships. The practical application of tender of performance requires knowledge of applicable legal frameworks, strategic approaches to dispute resolution, and awareness of the implications of non-performance. At the core, a tender of performance is the act by which a party indicates its willingness and preparedness to perform the duties stipulated in a contract. This act serves as a demonstration that the party is upholding its end of the agreement, which can prevent the other party from claiming a breach due to non-performance. In practice, this means that the party must not only be willing, but also capable of delivering the performance as per the contract terms. For instance, in a sales contract, the seller must be ready to deliver the goods on the specified date and at the agreed location, while the buyer must be prepared to accept and pay for the goods. The legal implications of a tender of performance are significant. When a party makes a valid tender, they have fulfilled their obligation to perform, even if the other party refuses to accept the tender. This protects the tendering party from liability, as they can demonstrate that they were willing and able to perform, thus shifting the burden of breach onto the non-accepting party. Understanding these dynamics is essential for contract law specialists who are tasked with advising clients on how to protect their interests in contractual agreements. One practical tool for managing tender of performance is the use of a performance checklist. This checklist ensures that all conditions of the tender are met, including readiness, ability, and proper notification to the other party. For example, a construction company can use a checklist to ensure that all materials and labor are available before the scheduled start date and notify the client of their readiness to perform. This not only facilitates compliance, but also serves as documentary evidence in case of disputes. Another actionable insight is the strategic use of communication in the tendering process. Clear and timely communication of intent to perform can prevent misunderstandings and conflicts. Contract law specialists should advise clients to issue formal notices of readiness to perform, which include detailed descriptions of the performance to be tendered. This can be particularly useful in complex contracts involving multiple deliverables or phased performance, as it clarifies expectations and reduces the risk of disputes. A framework that professionals can apply is the Four Corners of Tender approach, which emphasizes four key elements: intention, capability, timing, and place. Intention refers to the clear and unequivocal expression of readiness to perform. Capability involves ensuring that all resources and means are in place to fulfill the contractual obligations. Timing requires adherence to the schedule stipulated in the contract, while place pertains to the location where performance is to occur. This framework helps professionals systematically evaluate and execute a valid tender of performance, thereby enhancing their proficiency in managing contractual obligations. Case studies further illustrate the practical application of these concepts. In the case of British Westinghouse Electric and Manufacturing Co. Ltd v. Underground Electric Railways Co. of London Ltd, 1912, AC 673, the court emphasized the importance of a party demonstrating its readiness and ability to perform as a defense against claims of breach. Such precedents underscore the legal protection afforded by a valid tender of performance, reinforcing the importance of this concept in contract law practice. Statistics also highlight the significance of tender of performance in dispute resolution. According to a study by the International Institute for Conflict Prevention and Resolution, approximately 30% of contract disputes arise from issues related to performance obligations. This statistic underscores the necessity for professionals to master the intricacies of tendering performance, as it plays a pivotal role in preventing and resolving contractual conflicts. Pause. In conclusion, Tender of performance is a vital component of contract law that ensures parties fulfill their contractual obligations and are protected from unwarranted claims of breach. By employing practical tools such as performance checklists and strategic communication, and by applying frameworks like the four corners of tender, professionals can effectively manage and execute tenders of performance. Case studies and statistics further demonstrate the real-world impact and necessity of mastering this concept for successful contract management. For certified contract law specialists, proficiency in the tender of performance is not only a legal requirement, but also a strategic advantage in navigating the complexities of contractual relationships.